Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 14, we're continuing our detailed dive into Part 2, Public Records, specifically C, what records are covered, application of the Public Records, Act 2. We'll be navigating pages 102 through 114 of your manual. Our discussion will focus heavily on law enforcement records, Section 15, covering everything from arrest reports and criminal intelligence to Baker Act reports, body camera recordings, and various types of criminal history and forensic information, as outlined in your manual. Given the extensive detail, this episode will be significantly longer than our usual 15 minutes. Let's jump right into the complex world of law enforcement records. Segment 1. C. What records are covered? Law enforcement records, arrest, crime, and active criminal investigative and intelligence information, pages 102 to 104. Starting on page 102, we begin our deep dive into 15. Law enforcement records. This is a major category with many specific rules and exemptions. The first and arguably most important part of this section is A, arrest and crime reports, and the exemption for active criminal investigative and intelligence information. Let's break this down. First, 1. Arrest and crime reports on page 102. Generally, basic arrest and crime reports are considered public records once they are completed. This includes information like the time, date, location, and nature of the reported crime, the name, sex, age, and address of the person arrested, unless they are a victim with protected status, the crime charged, and the time, date, and location of the incident and arrest. The public has a right to know about criminal activity and official responses to it. Next, on page 102, the manual discusses the 2, purpose and scope of exemption. While basic information in arrest and crime reports is public, there's a significant exemption for active criminal investigative information and active criminal intelligence information. The purpose of this exemption is to protect the integrity of ongoing criminal investigations and intelligence gathering. Law enforcement agencies need to be able to conduct their work without prematurely disclosing information that could jeopardize an investigation, lead to the escape of suspects, or compromise undercover operations. The scope of this exemption is broad, covering records that contain information about ongoing efforts to detect, apprehend, or prosecute criminals. On page 103, we get to the 3 definition of active criminal investigative or intelligence information. This is critical because it tells us precisely what kind of information can be kept confidential under this exemption. Criminal investigative information typically means information with respect to an identifiable crime or criminal activity, including the documentation of efforts to discover, trace, investigate, or bring to trial a criminal offender. Criminal intelligence information usually refers to information compiled in an effort to anticipate, prevent, or monitor criminal activity. The key word here is active. The information must pertain to an ongoing investigation or intelligence effort. Following this, on page 103, the manual clarifies 4 information that is not considered to be criminal investigative or intelligence information and must be released unless some other exemption applies. This is crucial because it limits what law enforcement can withhold. It means that certain basic facts about a crime or arrest are always public, even if they are part of an active investigation, unless another specific separate exemption applies. For example, the basic facts about a crime, like the type of crime, when and where it happened, and the identity of the person arrested, unless a victim's identity is protected by Marsy's Law, as we discussed in episode 11, typically remain public. The exemption is for the investigative details, not the core facts of the incident. Then on page 104, we discuss 5. Records released to the defendant. If a criminal defendant is legally entitled to certain records as part of the discovery process in their criminal case, those records are released to them. This doesn't automatically make them public records for everyone, but it allows the defendant access for their defense, which is a constitutional right. Segment 2. C. What records are covered? Law enforcement records, active versus inactive criminal info and disclosure, pages 106 to 108. Moving to page 106, the manual further distinguishes between 6. Active versus inactive criminal investigation or intelligence information. This is a major point of contention and frequent litigation because the active status determines confidentiality. A. Active criminal investigative information on page 106 remains confidential as long as the investigation is genuinely ongoing. This means law enforcement is still working on detecting, apprehending, or prosecuting a criminal offender related to that specific information. This could include ongoing surveillance, interviews, forensic analysis, or attempts to locate suspects. Once the investigation is no longer active, e.g., all leads are exhausted, the case is closed, or a suspect is arrested and charges are filed, then the information generally becomes public unless another exemption kicks in. B. Active criminal intelligence information on page 107 is similar. It remains confidential as long as it's part of an ongoing effort to anticipate, prevent, or monitor criminal activity. This might involve intelligence about organized crime groups, terrorist threats, or ongoing patterns of criminal behavior. D. Pending prosecutions or appeals on page 107 also impacts active status. Even if the initial investigation is inactive, if the case is still moving through the court system, e.g., awaiting trial, sentencing, or an appeal is ongoing, some related information may remain confidential. The exemption can continue through the resolution of the judicial process. On page 108, we then cover 7 criminal defendants' public records request. This explains how a person accused of a crime can make a public records request for information related to their case. While they have access to discovery through criminal procedure rules, they can also use public records requests for other information subject to the active investigation exemption. Following that, on page 108 is 8, disclosure of active criminal investigative information to the public. The manual clarifies that active investigative information is generally not disclosed to the public. The purpose of the exemption is to protect the investigation. And finally, for this segment, on page 108, we look at 9, disclosure of active criminal investigative information to another criminal justice agency. Active investigative information can be shared between different criminal justice agencies, like local police, state prosecutors, FBI, etc., if it's necessary for their official duties. This allows for cooperation between agencies without making the information public. Segment 3, C, what records are covered? Law enforcement records, mixed records, info from, other jurisdictions, and prior info. Pages 110 to 111. Moving to page 110, we continue our discussion on law enforcement records, specifically focusing on some more nuanced situations. First, E10, records containing both active criminal investigative information and non-exempt information on page 110. This is a very common situation. Often a single record might contain some information that's exempt because it's part of an active investigation, but also other information that's not exempt. In these cases, the agency isn't allowed to withhold the entire record. Instead, they must redact or black out the exempt portions and release the rest of the record to the requester. This ensures that only truly confidential information is protected and the maximum amount of public information is disclosed. Next, still on page 110, we have 11, criminal investigative or intelligence information received from other states or the federal government. If a Florida law enforcement agency receives criminal investigative or intelligence information from an agency in another state, or from a federal agency like the FBI, that information typically maintains the same confidential status it had with the originating agency. Florida's law respects the confidentiality requirements of other jurisdictions, especially when it relates to ongoing investigations. Finally, for this section, on page 111, is 12 criminal investigative or intelligence information received prior to January 25, 1979. This is a historical note. The specific exemption for active criminal investigative and intelligence information became effective on January 25, 1979. Therefore, records created before that date might have different rules regarding their public accessibility depending on prior laws and court interpretations. This can sometimes create complexities for very old records. Segment 4, see what records are covered. Law enforcement records, Baker Act, body camera, confessions and confidential informants, pages 111 to 112. Now let's move to page 111 to cover several other specific types of law enforcement records. First, Born Baker Act reports, prepared by law enforcement officers, 15.B on page 111. The Baker Act refers to Florida's Mental Health Act, which allows for involuntary examination of individuals who may have a mental illness and pose a danger to themselves or others. Reports prepared by law enforcement officers under the Baker Act often contain sensitive medical and personal information. These records are generally considered confidential to protect the privacy of the individual experiencing a mental health crisis. Disclosure is typically limited to specific individuals, such as the person's attorney, guardians, or mental health professionals as allowed by law. Also on page 111, we have C, body camera recordings, 15.C. This is a very contemporary and often discussed topic. Body camera recordings made by law enforcement officers are generally considered public records. However, there are significant exemptions that allow agencies to redact or withhold portions of these recordings to protect privacy or the integrity of investigations. Common exemptions include recordings made in private locations, like inside a home, recordings of minors, recordings that depict victims of certain crimes, like sexual battery or child abuse, often linked to Marsy's law protections, recordings that depict individuals receiving medical attention, and recordings that reveal confidential investigative techniques. The specifics of what can be redacted are detailed in statutes balancing transparency with privacy and operational needs. Moving to page 100-12, we find D, confessions, 15.D. Generally, a confession made to law enforcement is considered part of an active criminal investigative record and thus exempt from public disclosure while the investigation is active. Once the investigation becomes inactive, or if the confession is formally filed as part of court records that become public, it would typically be accessible. However, during the investigative phase, its confidentiality protects the integrity of the case. And finally, for this segment on page 112 is E, confidential informants, 15.E. Information that could reveal the identity of a confidential informant, someone who provides information to law enforcement while wishing to remain anonymous, is almost always confidential and exempt. Protecting the identity of confidential informants is critical for law enforcement operations, as their safety could be jeopardized and their usefulness as a source would be eliminated if their identity were revealed. This is a very strong exemption. Segment 5, C, what records are covered? Law enforcement records, conviction integrity, criminal history, fingerprint and forensic, pages 113 to 114. Let's continue on page 113 to cover more law enforcement record types. First, F, Conviction Integrity Unit Reinvestigation Information, 15.F, on page 113. Some law enforcement agencies or prosecutors' offices have conviction integrity units that review past convictions to ensure justice was served and to identify potential wrongful convictions. Records generated during these reinvestigations are typically confidential and exempt from public disclosure while the reinvestigation is active. This confidentiality protects the integrity of the review process, allows for candid discussions, and avoids interference with potential new legal proceedings. Next, on page 113, we have GU's criminal history information, 15G. This refers to records that document an individual's arrests, charges, and dispositions, like convictions or acquittals. 1. Criminal history information generally, 15J1, on page 113, is often not fully public. While records of arrests and charges may be public, more detailed criminal history records, like those maintained by the Florida Department of Law Enforcement, are typically confidential and only accessible to specific entities such as law enforcement agencies for official purposes. The balance here is between public safety and an individual's privacy. 2. Sealed and expunged records, 15GB2, on page 114, are a very important subcategory. If a criminal history record has been officially sealed or expunged by a court order, it means that access to that record is severely restricted or entirely removed from public view. Sealed records are typically stored and remain confidential, usually only accessible by court order or to specific law enforcement agencies for limited purposes. Expunged records are typically physically destroyed or removed from record systems, making them largely inaccessible. The purpose of sealing and expungement is to give individuals a fresh start by limiting public access to certain past criminal history information, particularly for those who are arrested but not convicted, or for juvenile offenses. Also on page 114, we cover H fingerprint and genetic genealogy records, 15.H. Fingerprint records are highly sensitive and are generally confidential, primarily for law enforcement and identification purposes. Similarly, records related to genetic genealogy, which involves using DNA to trace family trees for investigative purposes, are also typically confidential due to the extreme privacy implications of genetic information. These records are protected to prevent misuse and to ensure the integrity of criminal investigations. Finally, for this episode, still on page 114, we have forensic behavioral health evaluations, 15.1. These are evaluations conducted by mental health professionals, often for court-related purposes such as determining a defendant's competency to stand trial or their mental state at the time of an offense. Because they contain highly sensitive medical and psychological information, these evaluations are almost always confidential and exempt from public records disclosure to protect the individual's privacy and the integrity of the legal proceedings. This concludes our detailed dive into the initial categories of law enforcement records, taking us through page 114 of your manual. Thanks for listening. In our next episode, episode 15, we'll continue exploring See What Records Are Covered by focusing on more law enforcement records, specifically sections 15J through 15S, which include geolocation information, juvenile offender records, motor vehicle records, and victim information, taking us through page 127 of your manual. Until next time, remember, the truth dies in the dark, so let's leave the light on.